Welcome to the Employer's Defense Podcast.
Hello and welcome to the Employer Defense Podcast with experienced attorney Clifton Smith. I am your host, Kevin Rosenquist, and today we're going to discuss strategies for defending wage and hour disputes. Clifton, great to see you again.
Great to see you.
All right, can you tell the listeners exactly what wage and hour law encompasses and why it is crucial for both employers and employees?
Of course. First, let me start by saying that this podcast is specifically for California employers who are held to a higher standard than employers in just about every other state of the nation. They have labor code requirements here that many states do not have. And so this will be most beneficial to California employers, although other employers outside the state may also find benefit from it. So wage and hour law encompasses such things as meal periods, rest periods, hours worked, overtime hours worked, correct reporting of hours worked, deductions and wages paid on wage statements, time records, penalties for failure to comply, additional payments for failure to comply, and exposure to litigation, including attorney fees and costs for failure to comply. And it's important for both employers and employees, obviously, because it involves payment of wages for time worked. Employees want to be paid, and they have a right to be paid for all hours worked. And of course, employers want to make certain that employees are working all hours for which they are paid. So it is kind of a mutual interest that arises from the agreement between the two parties.
How does it work? I mean, obviously there's hour tracking, there's wage tracking. Everybody has systems now in place. Where does the disconnect generally happen between the employer and the employee when it comes to this?
You know, I would say that the situation here is the employer is well-intentioned, but is not familiar with the requirements of the wage orders and the labor code in this state. And so, for example, they may make certain that an employee takes their half-hour meal period every day, but they are rather lackadaisical about the timing of it. And so instead of it being taken within 5 hours of the start of the shift, it's taken 5.5 or 6 hours after the start of the shift. And while the employer says, well, the employee received their meal period, well, they did, but it's not a compliant meal period. And there's consequences when you're not in compliance. And I think a lot of times what happens here is we're just dealing with employers who unintentionally violate the law because of their unfamiliarity with the labor code in this state, which is extensive.
I know that everyone is required to get certain meal breaks, certain breaks throughout the day. And I've managed people before, and you can tell them as much as you can, hey, make sure you take your break, make sure you take your break. But sometimes they don't, whether they're busy or they just forget or whatever. But it's still on the employer to make sure they take that break, right?
That is absolutely correct. In California, you're required to offer an employee an unpaid, uninterrupted 30-minute meal period where they stop all work and do so within 5 hours of the start of the shift. And if you don't comply with that requirement, then you are exposed to an hour of premium pay at their regular hourly rate to remediate the violation. When I call it an exception, when an exception occurs to a compliant meal period, in other words, you're not in compliance, then the next question becomes, who caused that exception? If it's the employer, you pay that employee an extra hour of premium pay and make certain that that exception does not occur again. If the employee caused it, my recommendation has always been to the employer, out of an abundance of caution, go ahead and pay the 1 hour of premium pay, but then you need to address the behavior with the employee to eliminate the recurrence. In other words, you counsel that employee, or if appropriate, you institute progressive discipline with that employee and make it clear to the employee that if they are not taking these meal periods and this continues, they'll be let go.
Wow, what a crazy, I can't even imagine being like, why'd you get let go from your job? I wasn't taking my breaks.
Yeah.
What are some of the key regulations and statutes that employers really need to be aware of in wage and hour disputes?
Well, let's start with the wage orders. California has 17 different wage orders. And, we live in the age of Google, where you can find anything. And so you can just Google California wage orders, and all 17 will pop up together with the minimum wage laws. You need to find your industry within those 17 wage orders, print that wage order, and read it. and it is extensive, and it tells you almost everything you need to know about legal compliance with California wage and hour law. In fact, you're supposed to have that same wage order posted in your place of business so that all your employees can see it. So start by reading it and making sure you understand what's required, and then get it posted so your employees can see it as well. It's required in this state. So that's a big step. You need to make sure that you have a wage and hour reporting system, a timekeeping system that records all time worked down to the minute, that will record unpaid meal periods when they are taken and when they end, so that you have a record that protects you. Because these aren't just employee records. These records are meant to protect the interests of the employer, to show compliance. And they must be completed by the employee, not the employer.
Okay. And does this go for salary and non-salary employees?
No, we're really principally talking about hourly paid, non-exempt employees. We're not talking about professionals. We're not talking about legitimate supervisors, managers, or say, legal professionals or others who fall into the salaried category. But again, in this state, be careful. Don't misclassify your employees. Don't try to finesse a classification to call an hourly paid employee salaried. I remember an employer who took the approach that everyone in their marketing department was going to hold the title of manager, so that when a customer called, they would always be speaking with a manager and felt like they were getting the attention they deserved. And while that might be an excellent marketing strategy, it has absolutely no meaning whatsoever in the context of wage and hour law, okay? And any investigative agency, any plaintiff's attorney, any judge and jury are going to look right past that title, and they're going to look first at what you were paid, but more importantly, what your work was. And if you spent more than 51% of your time engaged in other than supervisorial pursuits, you will be deemed improperly classified, and the employer will be paying an inordinate amount of money to compensate for that mistake.
How do recent changes in wage and hour laws impact employers' responsibilities and defense strategies?
Basically, the wage and hour laws have largely been in place now for nearly 2 decades. And, employers have been struggling with them. I would say principally what we've been looking at for nearly the same period of time is class action, wage and hour lawsuits for meal period, rest period violations, and then PAGA violations. Now, one of the more recent developments that is beneficial to California employers is the use of arbitration agreements to limit or eliminate claims under class action, to eliminate class action lawsuits. And that's something that's done at the handbook stage when you're distributing and reviewing your handbook with your employees. And that's an excellent way to markedly limit your exposure.
Yeah, I remember that back from my managerial days. We brought in an HR person, and it was handbook. That was a big thing right out the gate.
Absolutely. It's not just for the employees.
Right.
To let them see that, what your rules and regulations and benefits and et cetera and all that are. It may be the only policy statement you have that managers and supervisors can utilize to guide them. So it's incredibly important.
Yeah, it's sort of like the playbook for what the expectations are for everybody at a company. Can you describe a successful defense strategy for maybe a common wage and hour claim?
Yes, that strategy actually begins before the lawsuit is ever filed. If you're going to do business in this state and you're going to have employees, you have to start with a time and payroll system that accurately captures all time work down to the minute. This state does not let you round so that, let's say, somebody comes in 10 minutes before the start of their shift, you can wait until the shift starts to pay them. No. In this state, when you clock in, you're on the clock, and you have to address that behavior through disciplinary action if you want it to stop, but you have to pay them for all time worked. And the same holds true for meal periods. The employee must take a 30-minute meal period. You cannot round up or round down. If the employee takes only a 29-minute meal period, the employer is in violation. That's an exception. The employee must have that 30-minute meal period. Any time worked over 8 hours in a day must be paid at time and a half. And there are other overtime requirements as well. So, again, a time and payroll system is absolutely critical to the employer's defense. You must be able to show that the employee has been paid for all hours worked, that the employee has received their meal periods, and if not, the employee has been paid premium pay for those exceptions. And it's just the oversight that's required is absolutely the best defense you can take before a lawsuit ever begins, because if and when it begins, you've got your evidence at the ready showing you are California compliant.
What other documentation is critical for defending against wage and hour claims? And what types of records are the most important?
Again, the most important records are going to be time records, payroll registers, any meal period agreements. If you have some type of second meal period agreement that allows you to waive the second meal period because you've already taken the first meal period and you're going to work less than 12 hours in the day, there are certain circumstances under which you can waive a second meal period. You've got to have all your waivers in order. You want to have a handbook that sets forth the policies and procedures concerning, for example, meal periods, rest periods, working overtime, whether and when a supervisor's authorization is required. All of that is critical to a defense of the lawsuit. You're really looking at a document-intensive inquiry when defense counsel gets involved. That's the first thing I want to look at, because that will really determine, again, whether and how effective the defense can be.
When it comes to small businesses that have a very limited staff, maybe they're a mom and pop, maybe they only have, a handful of employees, they don't have an HR person. What would you tell them is the best way for them to be prepared to ensure that they have all their ducks in a row, and can help prevent this type of thing from coming up?
Just had that situation arise literally with an employer who contacted me who is located outside the state, but they're going to hire their first California employee. And that
remote employee?
That remote employee would be working within the state of California. And my advice to that employer, and my advice to any employer like this, is you incur the expense to hire a payroll company that will process your payroll. And, there's so many out there. I'm not going to be a plug for any one of them right now, but they've all had more than 2 decades to become familiar with the requirements of meal period, rest period laws in California, as well as California's overtime requirements. And you can find a payroll system that is California compliant. I strongly urge any employer who's only going to have 1 or 2 employees to hire that payroll company to process that payroll, again, because of the importance of the time records, showing that meal periods are taken, showing to the minute how much time has been worked to determine if overtime is required. Those things are absolutely essential for any employer. Even if you don't have the money to hire a payroll professional or a human resources professional, at a minimum, you have to have a payroll processing company help you.
Yeah, and a lot of those payroll processing companies, they have HR products, like with a fractional HR person, if you will, that can come in and help you with things. So that would probably be an excellent opportunity to work on your handbook and get things prepared.
It is. It's worth its weight in gold. You're absolutely right. That's one of the best things you can do. You just need to understand, if you're going to do business in this state, you're going to incur that expense that you wouldn't incur otherwise.
Right. What are some of the common pitfalls that employers should avoid when a claim is made against them in the wage and hour realm?
Typically, when the claim is made, the die is already cast. Mistakes have already been made, which is why the claim has been made. I would simply say at that point, what you need to do is recognize that you've got litigation or a claim pending. You're going to need legal counsel. So first and foremost, you want to locate legal counsel that can guide you. And that attorney, whoever that attorney is going to instruct you to preserve all records, to not destroy any records, to not have any conversations really with any supervisors or managers unless the attorney is present, because that is the way that you can protect those conversations. If the employer starts walking around speaking to all of its supervisors and managers and giving details, all of that must be disclosed to plaintiff's counsel unless defense counsel is part of that conversation. So you want to get defense counsel involved very early.
Yeah, I've definitely worked at some small places where, maybe the higher ups are a little too cavalier with some of the things that they say. So I could definitely see that could be a problem where if an employer starts talking about things maybe that they shouldn't. And certainly in this day and age with text and all that, you've got records of things, which could be could be incriminating.
I know of one occasion where plaintiff's counsel sat with the defendant and defense counsel in a deposition and asked the question, did you hold a meeting? And the deponent said, yes, we did. And who was present at the meeting? And the deponent proceeded to list all the managers and supervisors that were there. And then the fateful question, and was counsel there? No. Was counsel available by microphone or speakerphone? No. So no attorney was present? No. Tell me everything that happened, everything that was discussed in that meeting. And they had to tell the deposing attorney everything that was discussed in that meeting because it wasn't privileged. That's what can happen.
Did every manager get asked as well? Is that did everybody have to talk about it, or was it just like the employer themselves?
Potentially everybody has to talk about it if they're asked. At that point, it was just one deposition of one individual. But that individual gave up a wealth of information that should have been protected.
How often do these kind of cases come across your desk?
Frequently, because people don't go into business to be attorneys.
Right.
They go into business to be successful at what they do, right? And they're not accustomed to being sued. Who is? Until you've gone through it, you don't know what it feels like. It can be a very unsettling experience. And you start to find out that things you would normally do, you can't do because of litigation.
And in your experience, it's often just a mistake or overlooking something rather than, a blatant disregard for the rules by the employer or the employee bringing a frivolous lawsuit. It's usually just kind of a oops, I screwed up.
Yes, although I will say there's a fine line between an innocent mistake and deliberate indifference. If you're engaged in deliberate indifference and you think you can just get away with it, you're going to have problems out here. You won't get away with it. But, if you're really trying to comply with the laws, or you weren't aware that compliance was required in one particular area, then you're in good company with a lot of other employers who also made the same mistake.
Well, thanks for tuning in to the Employer Defense Podcast with experienced attorney Clifton Smith. For more information or to connect with Clifton, you can visit cesmithlaborlaw.com. And of course, be sure to hit that like and subscribe button and leave us a review in the comments. Clifton, always great to see you. Thanks for being here.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.